On the 17th of May 2025, the advisory group of experts has met to interview the candidate for the position of a judge of the Constitutional Court of Ukraine, Andrii Savchak. We have all members of AGE here. AGE Secretary Marina Konner, member Hanna Sukhotska, members Vasyl Shakun, Yaroslav Ramanyuk, Mr. Alesh Zeller, and me, the chair, Oksana Vasilchenko. Also, during the interview, we have here deputy members of the AG, Mr. Marek Zubik, Thomas Griffith, and Vitaly Makhinchuk. And I should note that we are working in a shelter, so in the event of an air raid alert, the interview will continue. I would also like to remind you that the interview is being recorded and broadcast live on the resources of the AG and the Constitutional Court of Ukraine website. I also would like to draw the attention of the members and the candidate to restrict use of sensitive data and restricted access information on air. If it is necessary to discuss such issues, the broadcast will be terminated. We are now ready to start, and I will pass the floor to Marina Konner, Secretary of the AG, for a brief introduction and reminder of the schedule. You're welcome.
Thank you. Greetings, dear colleagues and everyone who is watching and our candidate. As Chair Vasilchenko has already said, the advisory group of experts will now interview the candidate, Andrii Savchak. I would like to remind you that the interview is part of the assessment stage of the candidates to determine their compliance with the criterion of high moral qualities. As before, one interview is allocated approximately 1 hour, and the time limit for answering questions, each question is up to 3 minutes. Traditionally, we ask all candidates to be concise, to answer clearly, unambiguously, and to the point. At the end of the interview, the candidate may make a short closing statement of no more than 5 minutes. I should also note that during the processing of materials about the candidate, the AGE sent him questions for written explanations, so the candidate has had the opportunity to prepare and to provide answers. So let me briefly introduce the candidate. Andrii Savchak is a judge of a district court in Lviv region. He also holds a PhD in law, and in 2009 defended his thesis on the constitutional and legal views of Stanislav Dnestriansky. Mr. Savchak, if you would like to add anything to your presentation, you can do that now in 2 or 3 minutes, and then we will afterwards begin with the questions.
Ні, дякую.
No, thank you.
Okay, so colleagues, please begin the questioning.
Андрію Володимировичу, ми вже під час письмових раундів задавали.
Andrii Volodymyrych, during written communication, we have already asked some questions, and now we would like to clarify and hear more details about those questions that we previously asked you. In particular, we discussed that on 2 cases of administrative offenses and Article 130 of the Code of Ukraine on administrative offenses, you as a judge applied sanctions under this article, however, without depriving the individuals of the right to drive vehicles. If you check the text of the article of the Code of Administrative Offenses, the sanction of this article, 130, is non-alternative and provides for mandatory simultaneous application of both fine and deprivation of the right to drive vehicles for the period of 1 year. At the same time, for those 2 cases, you did not apply the sanction, the privation of the right to drive. How can you explain that? And also, how did you justify that you did not apply that sanction? Shall I remind you about those cases? No, that's okay, I have that. Thank you. That's true that I heard two cases, very similar cases, and in each of those cases, the driver was stopped and they refused to undergo the examination and test. In each of those cases, in the car, there was another individual who they were taking to a hospital, or the other one was going back from the hospital. In the both cases, that was basically a mother-in-law. So one person had cancer. In the other case, that lady needed to go to the hospital once or twice a week for hemodialysis. So considering the circumstances that they had to take that woman almost every day or at least twice a week to hospital, and considering the fact that we are in the situation of the martial law, we have shortage of drivers, and that requires a travel 1.5 hours of travel to Lviv, I could not do otherwise. So I took into account the circumstances that actually I could not be sure that they were under the impact of alcohol. There were no obvious signs, and they refused to take the test. However, they explained the circumstances, and in each of those two cases, the drivers did admit that they drank some alcohol the previous night. If that was about fear, if they were cheating, I cannot be sure, but I decided to balance the interests, and it seems to me that the decisions I made were adequate, were right. And I was aware of that I would be asked about those decisions because they are in public domain, but under those circumstances, I could not do otherwise. The motivation for those decisions, I tried to explain that as much as detail as possible so that people could see my rationale and the grounds. And also, it's not a massive case. Each year I hear at least 70 cases under 130 under this article. So it is just, these were cases one last year. So okay, so when you made decisions on this category of cases, almost every day you hear those cases, and Article 130, that was about the balance of interests of state and protection of rights of individuals. Yeah, of rights of those relatives who could suffer if I deprive them of their driving license, because to travel from a village, an adjacent village, to Lviv, it's very hard. It's a challenge because there are almost no men now, women, a lot of young people left abroad. So I don't know. I made that decision. I tried to motivate and to explain that in my decisions, my resolutions. Thank you, Andrii. Same, and also a number of questions about the sources of funds for purchase of real estate. As we discovered, for a certain period of your professional life, you worked in Kyiv as a research advisor of a judge of the Constitutional Court of Ukraine, and you confirmed that your parents signed an investment agreement to purchase an apartment, and it was intended that you would live there with your family. In particular, your mother entered into that investment agreement to eventually buy an apartment in Kyiv region. Yes, 2-bedroom apartment. The total price of the apartment, more than 340,000 hryvnias under the investment agreement. At the same time, according to data of the State Register of Individuals, the total income of your parents starting from 1998 through 2006 was 145,000 before deduction of cases and other mandatory payments. So the official income of your parents was not sufficient to invest into that apartment. So can you explain the sources of these funds that made it possible for your parents to buy the apartment? As it was explained by my parents, those were their savings. I'm not ready to go into detail, and I don't have confirmatory documents, so I could not provide you with anything there, but definitely that was not my money. And my parents, they work, they are not criminals, they have not been public officials, so they could not earn this money illegally. So have been saving. If I could provide you with more evidence, I could do that. Okay, what's now happening to that real estate property? It is there. I mean, our relatives used to live there. Now, as far as I know, IDPs, internally displaced people, are living there. It is still the property of my parents. Let me clarify my question. So this is still livable. It's possible to live there. Yes. And how did you conduct the repair and buy the furniture to make it livable? So what were the sources of those funds? There, we were supported by our relatives from Volyn. The relative came to do the repair work. This is my father's. Well, he has a sister, and that's the son-in-law of that sister. He has a team of workers, a brigade, so they came to work on the walls and on the floor, and there is basic furniture to sofas. We don't even have a proper kitchen set there. Thank you. Hanna, do you have questions there?
Yes, I have some questions concerning discrepancies in the candidates' declarations. We have many examples of such discrepancies. I don't like to quote here all of them, but only some of them. For example, in your 2015-2016 declarations, you indicated the date of acquisition of the right to the apartment in Lviv, where you live with your family, as 28 August 2007. Also, you actually started living there in 2012. This first example. Second, in the declaration for 2023, you did not declare the remuneration received by your son in the amount of Ukrainian hryvnia 10,000. Comparing your paper and electronic declarations for 2015, we can see that the electronic declaration does not contain income received in the form of dividends and interest. Also, you have indicated this information in the paper declarations. Then the next example, in the 2015 declarations, there are discrepancies in the amounts of family members' funds on accounts in the banks and other financial institutions, and the value of family members' securities. Then, in your 2017 declarations, you did not disclose your wife's income of Ukrainian hryvnia 64,000 received as insurance payment from MetLife agenda. So I don't like to give more examples, but I would have a general question to you. How you can explain these differences? Why are these discrepancies so systemic? Because we can see it in different years. What is your explanation concerning this situation?
Дякую.
Thank you. I would like to attract your attention to the fact that all of these discrepancies, they existed there before 2017. All those documents filling out those declarations, that process required my work with paper documents, and I was trying to do my best there. And it is quite possible that there are some minor discrepancies, and I attribute that to that. After I was subject to a qualification assessment and deemed it was deemed that I can work in court. I started checking that and cross-checking that information. I registered my tax account, e-account, and I tried to check, cross-check, and repeatedly check all the information about me and my wife. And after that, there were no discrepancies. Only this 10,000 that my son got. Well, he's minor, and he participated in local competition, so he was a winner in that competition, so that was an award. And of course, in tax declaration, I did not register him, and frankly speaking, I just forgot about that. But, well, I knew that this kind of award also was to be indicated, but I was not sure that a minor individual can have any income that is taxable and registerable. And also well, I understand that 60,000, it looks a lot, but this is the money that my wife was paying for 10 years. It was accumulated. Back in 2016, I didn't cross-check that against tax administration data, and I didn't indicate that. But that's official, and tax administration has information about this fund, so I didn't have this intention to hide it, and it would make no sense, basically. Any other comments that you would like to hear?
You see, you try to explain us something, but you know, you are running for the post of the judge in the Constitutional Court, and in your opinion, can such a number of errors, because it was not very convincing what you said, errors in your declarations, cause an outside observer to doubt that you have diligently, thoroughly, and responsibly fulfilled your statutory duty in making your declarations? We have a lot of doubt, yes, because, you know, such vacuums in the declarations and discrepancies. How to say, say about it?
It's good that I am not going to be the head of the tax administration where you need to know how to count money, calculate money. But yes, I've made these mistakes, but also let me state that I have corrected this situation. Since 2020, I believe I have not committed these mistakes. And the more so that now there is this helpful function when you submit the declaration, it's possible to cross-check the data against various registries. So due to that, to a great extent, I've managed to avoid mistakes. While in the previous years, in 2015 and 17, those were the first years after introduction of e-declaration. And even technically, that could happen as with the dividends, they were on paper. I was quite sure that I also mentioned that in the e-declaration. Maybe I just didn't push the button save. That's also possible. So I hope that if you analyze the declarations in the recent years, you will see that there are no discrepancies eventually, and I hope that you will take that into account when you make your decision.
This issue.
Дякую.
Thank you. Andrii Volodymyrovich, also when you participated in the competition for the member of, no, it's not the competition, I mean when you applied for when you had qualification assessment, right? There was the question about sources of funds that made it possible to buy the apartment in Lviv that belongs to your wife. Could you once again explain what the sources were that made it possible for you to buy the apartment? Right. As I mentioned in my comments, actually, that was the funds, the money that me and my wife earned in the process of our work life. So I conducted the calculations, and you can see that in the period from 2007 through 2015, the average income for me was about $16,000 a year. And I approximately estimate, based on the annual exchange rate, well, basically, the apartment was just $26,000. That was the cost, and also about $8,000 was the cost of repair. And based on official, the income that I had confirmed, and that is known to the tax administration, that makes it possible to buy the apartment. There were no other sources of income apart from those declared. Thank you, Andrii. Colleagues, do you have questions to the candidate? I do have a short.
I may.
Пан Алеш, перепрошую, пан Василь уже почав задавати.
Sorry, Vasil has started asking a question. That's a short question. Where does your wife work? My wife works at a medical center as a doctor and dietologist. What's her average income monthly? Well, recently about 30,000. Thank you. Yaroslav? Thank you. No microphone, sorry. So you have considered many cases under Article 130, and how many cases like that have you heard? In the recent previous years, in the recent 2 years, maybe about 70. So all in all, it is about 700. So it is 70 on the annual basis, because we paid attention to 2 decisions in this category of cases. Have there been other cases when you applied in that way the sanction? No, no other cases. That was only in the context of the martial law, because I understand that the law is a law and we need to comply with it. But maybe you closed so these cases, and because of the expiration of the term, well, maybe there have been several cases like that, but I'm not ready to tell you. But at least the group of experts did not discover these cases. Alish, you're welcome.
Thank you. I would like to ask the candidate a question which relates to the question concerning the purchase an apartment in Vasilkiv, which was actually owned by candidate's mother. So my question is, for what purpose did your mother issue powers of attorney in your name to dispose of this apartment?
Well, my mom is elderly, so for a certain time until 2020, I worked in Kyiv, and if it was necessary to enter into a contract, maybe with municipal authorities, some utility stuff, so that I could sign those documents. And after I moved to Lviv to work in Lviv region, it's also 550 kilometers, so she cannot travel. And that is why she issued these powers of attorney, but I've never used them. Now,
Of the construction financing contributed by your mother?
as far as I remember, it was about $40,000. And there was some additional payment, extra payment. I don't remember for sure, but that's minor.
And who of bringing the apartment into the habitable condition?
The parents, my parents.
Я не робив.
No, I didn't.
Just one clarification. As regards the discrepancies in your declarations, you said that after 2017 there was no problems anymore. But what about the declaration concerning the value of apartment, which amounts to 860,000 Ukrainian hryvnias, you declared, and these declarations actually are from the period 2017-2024, while according to the copies of documents provided by you, namely the gift agreement, the market value was lower, was 758,894 hryvnias. So why here a discrepancy?
Я надавав додатково.
I provided the explanation and also a copy of the valuator's opinion, valuator's report. The copy of the valuation report is in the file, in the documents that we keep with the wife. So according to the valuator, the price of the apartment by our address is, as you mentioned, 860,000 hryvnias. However, this valuation was only valid for 6 months. As far as I understand, after that, when I entered into the subsequent contract, another valuation was conducted, and thus there was another figure in the gift agreement. So since in our documents, me and my wife, in our folder, we have that first valuation, I indicated that price, and it was only upon your query, when I checked the gift agreement, I could see the discrepancy. But I had that valuation report in my files, and this was the figure that I knew.
There's another recent declaration from the year 2023. You did not declare the remuneration received by your son in amount of 10,000 Ukrainian hryvnias. Why this?
Як я вже пояснював, я
As I have already mentioned, I check my income against the tax administration's data. My son is minor, so I did not request that notice from tax administration. So I just didn't check that against the figures in the tax administration, and I forgot to mention that. But that's official. It's official income.
My point is just that it's not just a period until 2017 where we found out these discrepancies, but also in the later period. So thank you for your answers. I have no further questions.
Дякую.
Thank you. Please switch on the microphone. Since 2013, you are teaching at the National School of Judges. What's that? Well, initially, I taught the courses that were required. But after 2015, we worked, for example, to develop the training courses. And the first one was on Article 8 of the Convention of European Convention for Human Rights and Fundamental Freedoms. And there we developed a course for judges on that particular article. That took us about 2 years to develop it, to pilot it, and then to start using it. After that, there were 2 more courses on gender equality and non-discrimination. Those were also training courses for those individuals who studied at the school to further and become judges, and there were specific courses for judges, for candidates for judges and for judges, yes, for both. And also there were separate courses for the staff, for assistants. And after that, in 2019, 18 or so, we started developing the training course on international humanitarian law. And it took us about 18 months to develop that. And then when in 2022, since 2022, and now I deal with war crimes. I teach at the school, I can attend trainings. That's very relevant now. And you teach judges. Yes, judges. I go to regions in Kyiv, Kharkiv, Odessa, remotely. There are colleagues from eastern regions who travel to attend those trainings there, but since they have limited number of people, they sometimes invite colleagues from western regions to teach this, and that's okay for me because it is remote training, so it's no problem for me to allocate this couple of hours. Okay, thank you. Dear colleagues, any other questions to the candidate?
We will give the candidate the opportunity to take up to 5 minutes for closing statements.
Дякую.
Thank you. Yes, I would like to use that. So it's my honor to contact the advisory group of experts as a candidate for the position of the judge of the Constitutional Court. I hope that my answers and documents submitted will help you to come up with the proper opinion about me as a candidate and to address any doubts about my compliance with the criteria. And let me assure you that to the extent possible, I try to respond to each of those questions truthfully. I have provided all the available confirmatory support documents that I was able to get hold of. During my work as a judge, I have not committed anything that would undermine authority of justice, and I tried that my conduct and professional activity in my individual life were in line with criteria of professional ethics and integrity. And a couple of words about why I'm here. For 6 years, I worked at the Constitutional Court at the position of a research advisor to a judge, and that's not just a formal position. My experience of work in the Constitutional Court not just gave me some knowledge, but also helped me to better understand the work of the Constitutional Court. This experience is very valuable for me because due to this work, I was able to develop my capacity to analyze, assess the situation, to do the comparisons, conduct comparison of various concepts and legal provisions. And during the recent 12 years, I've been the judge, and I've been applying provisions of the legislation in practice, and also I teach at the National School of Judges, and I try to keep up my professional development. And the fact that I had this experience of work in the Constitutional Court, my research work, and the experience as a judge and of a district court gave grounds for me to apply for this competition. I understand the value and significance and the status of a judge of the Constitutional Court, and of the court in general. For me, a judge is a carrier of those constitutional guarantees and rights, the individual who has the duty to balance the branches of power and to ensure protection of human rights. I understand the sensitivity and all the challenges around the resolutions of the Constitutional Court and the impact. I am ready to the challenges that the Constitutional Court is facing, and if I am if I am selected as the judge of the Constitutional Court, I will use my professional skills to enhance the confidence in the court and in the judicial system. Thank you for your attention. Thank you, Andrii, for your answers. Now, dear colleagues, here the interview of the advisory group of experts with the candidate for the judge of the Constitutional Court is completed.